Imagine two cars colliding at a suburban intersection. If you were sitting on a jury, you could likely determine who was at fault by looking at skid marks, traffic lights, and witness accounts. The rules of the road are common knowledge. Now imagine a subtotal thyroidectomy, where massive scar tissue has completely obscured the patient's normal anatomical landmarks. If a surgeon damages a hidden nerve during this procedure, how do you determine if they made a careless mistake or an unavoidable error? In ordinary negligence cases, like the car crash, liability is judged against an objective standard, the reasonably prudent person. We ask what a normal, careful individual would have done in that exact situation. But that standard collapses in an operating room. A lay jury simply does not possess the scientific training required to evaluate the intricacies of complex medicine or technical analysis. You cannot ask what a reasonably prudent layperson would do during a thyroidectomy. To understand how the law bridges this gap, we have to look at the baseline foundation of all tort claims. A plaintiff must prove 5 essential pillars to establish a prima facie negligence case: duty, breach, actual cause, proximate cause, and damages. Because a layperson cannot independently assess technical medical procedures, the law entirely alters the specific rules inside these pillars for specialized fields. Understanding professional malpractice requires deconstructing how the courts redefine who qualifies as a professional, how the standard of care shifts, and why expert testimony becomes the ultimate gatekeeper of evidence. Before any specialized malpractice rules can apply, a court must first legally classify the defendant's occupation as a profession. Consider the case of Lewis v. Rodriguez. An employee was fired after failing a polygraph test and sued the examiner for negligence, arguing the examiner misread the deceptive scoring results. To determine which rules applied, the court had to decide if a polygraph examiner is legally a professional. They evaluated the role using a strict set of criteria. First, the work must be predominantly intellectual and non-routine. An examiner has to assess the psychological suitability of each subject and carefully interpret entirely unique physiological data. Second, the occupation must require knowledge customarily acquired through specialized intellectual instruction or state licensure. Polygraph examiners attend specific schools, complete supervised internships, and obtain a state license. Third, and most crucially, the daily duties must demand the consistent exercise of independent discretion and judgment. Formulating the right questions and assigning scores to the biological feedback relies heavily on the examiner's independent analysis. Finally, the output produced cannot be strictly standardized to a given timeframe. Every examinee and every test is unique. Because polygraphy meets these strict criteria, the court ruled the examiner is elevated to a professional status. Once this threshold is crossed, the actor is shielded from the ordinary reasonable person standard. Their conduct is now measured exclusively by the specialized customs and accepted practices of their trade. With the defendant classified as a professional, we can examine how the law mutates the first 2 pillars of our tort model, duty and breach. In ordinary negligence, you owe a universal duty to not harm foreseeable people around you. In malpractice, this transforms into the relationship requirement. A professional owes no duty of care until a formalized relationship, like doctor and patient, is explicitly established. The benchmark for a breach also shifts. You are no longer judged against an average person, but against the customary practice of a minimally competent professional in that exact field. Historically, this competence was judged by the Locality Rule, a concept aggressively challenged in the medical malpractice case Hall v. Hilbun. Under the Locality Rule, a physician was only measured against the knowledge and customs of other doctors operating in their exact same geographic neighborhood. The court in Hall abandoned this outdated geographic limitation. Medical education, internships, board certifications, and scientific principles have become standardized across the entire country. They adopted the modern rule, the competence-based national standard of care. The underlying logic is clear. Human physiology is identical everywhere. An abnormal blood sugar count or a pulse rate of 140 indicates the exact same physiological danger in rural Mississippi as it does in a major hospital in Ohio. There is, however, a vital exception built into this national standard, the resource-based caveat. While a doctor's core medical knowledge is judged nationally, the courts will not penalize a rural practitioner for lacking the sophisticated imaging equipment, specialized surgical personnel, or advanced facilities found in urban research hospitals. This modern framework balances a rigorous demand for national scientific literacy with the practical, physical limitations of localized healthcare resources. To prove that a professional breached this national standard of care, the law imposes strict evidentiary rules. In the case Downer v. Liu, a patient admitted in shock with multiple severe bone fractures sued her general surgeon. She argued he committed malpractice by treating her himself instead of calling an orthopedic specialist. The court ruled there is no strict legal duty to consult a specialist, as long as the general practitioner possesses the requisite skill and their chosen treatment aligns with recognized medical standards. To understand exactly how a plaintiff must prove that a treatment failed those recognized standards, we look to Walski v. Tsenge. During a complex thyroid operation, the defendant doctor faced a surgical dilemma caused by massive scar tissue. He had to choose between exposing a delicate nerve and risking direct damage to it, or intentionally skirting the area entirely to be safe. He chose to skirt it, and the patient unfortunately suffered vocal cord paralysis. At trial, the plaintiff's expert witness testified that, based on his personal preference and training, the nerve must always be explicitly identified during the surgery. The court rejected this testimony. The expert failed to establish that his personal preference was the universally accepted medical standard. He only proved what he would have done, not what the entire medical community requires. An expert merely stating they would have done it differently is legally worthless. The plaintiff's expert must prove that the defendant deviated from a generally accepted community custom. The law requires this high bar because medicine is not an exact science. Differences of opinion between equally skilled doctors are a normal, necessary part of exercising professional discretion. If a professional makes a good faith election between two valid recognized procedures, it is not malpractice, even if that choice ultimately results in permanent injury. The law intentionally insulates professional judgment from hindsight bias. A tragic outcome does not automatically equal a breach of duty. While expert testimony is the strict gatekeeper for proving a breach, there is one rare exception to the rule. It is known as the common knowledge exception, which often overlaps with the doctrine of res ipsa loquitur, meaning the thing speaks for itself. During the autopsy in the Hall case, medical examiners discovered that a surgical sponge had been left inside the patient's abdominal cavity during the operation. This type of mistake bypasses the expert mandate. The error is so glaringly apparent that a layperson needs no specialized medical training to understand that the standard of care was breached. The same logic applies if a surgeon amputates the wrong limb, or if an attorney entirely forgets to file a lawsuit before the statute of limitations expires. This exception acts as a crucial legal failsafe. It ensures that professionals cannot hide behind a wall of expensive experts when their negligence is plainly obvious. When we review the foundational model of negligence, the complete transformation for professional malpractice becomes clear. The concept of duty mutates from a universal obligation owed to everyone into a strict relationship requirement between practitioner and client. The standard of care abandons the reasonably prudent person and the outdated locality rule, replacing them with a national standard of minimum competence adjusted for local resources. And the evidentiary rules recognize that lay juries cannot independently judge specialized sciences, making expert testimony the mandatory translator of industry customs. This specialized framework is not designed to punish doctors, engineers, or attorneys for tragic, unavoidable outcomes. The professional negligence framework exists to hold practitioners accountable to rigorous national standards, while firmly protecting their necessary independent judgment from the emotional reactions of lay juries. In malpractice, custom is the law.